because you intended to destroy the tree and thus intended to cause very serious damage to property. It falls into the highest harm category because of the social impact of the offence, causing serious distress to many people. This yields a sentence range of 6 months to 4 years custody, with a starting point of 1.5 years custody. On count 2, the prosecution submits that the criminal damage to Hadrian's Wall falls into category B, medium culpability, on the basis that you were reckless as to whether your actions would cause very serious damage to the wall. I accept this categorisation. I also accept that the damage to the wall, unlike the damage to the tree, is capable of financial valuation, and that the costs associated with repairing the wall, including the staff cost to the National Trust, amount to just under £7,500. For an offence of medium culpability and harm falling into category 2, the sentence range extends from a medium-level community order to 9 months custody, with a starting point of a high-level community order. Count 1. Under the guidelines, the starting point for an offence of criminal damage falling into the highest bracket of culpability and harm is a sentence of 1 year and 6 months custody. However, I must then consider adjusting that starting point upwards or downwards, as may be necessary to reflect the particular features relevant to culpability and or harm in the particular case. I have no doubt that the starting point of 1 year and 6 months custody must be adjusted upwards in your cases for a number of reasons. First, because there are 2 factors, each of which bring your offending within the highest culpability bracket. More significant, however, is the extraordinary social impact which I've described of your offending, and I've no doubt that these factors justify an increase in the starting point to the very top of the guideline bracket for this offence, before consideration of aggravating and mitigating factors. The guidelines then require me to take into account any aggravating factors. One aggravating factor specified in the guideline is the fact that damage has been caused to a heritage and or cultural asset. However, I accept that I must be cautious not to double count aggravating factors. I've already substantially uplifted the starting point to reflect the very widespread distress caused by the felling of the tree. This reaction is in large part linked to the tree's status as part of the landscape and part of our natural heritage. It would be wrong to uplift the sentence still further for what is essentially the same reason. Mr. Graeme, you have 4 previous convictions, 2 for battery and 2 for public order offences. Your previous offending was linked to relationship difficulties, and in each case you received a financial penalty. I do not regard your previous convictions as relevant to the sentence which I must pass today, and I do not regard them as aggravating factors. However, there is a further aggravating factor not specified in the guideline which justifies an increase in the sentence. You appeared to savour the fact that others, including a teenage boy, were investigated for the offences which you had committed. This additional aggravating factor leads me to the conclusion that before mitigation is considered, the sentence falls over the top of the guideline bracket of 4 years imprisonment. I'm then required under the guidelines to take into account mitigating circumstances. I've read detailed pre-sentence reports, and in your case, Mr. Graeme, a mental health assessment report prepared by the Crown Court Mental Health Liaison Team and a further expert report prepared by a consultant forensic psychiatrist, Dr. Steve Ramplin. Daniel Graeme, you are now 39 years old. You've worked for most of your adult life, and I've read testimonial statements which, amongst other things, say that you are hard-working, polite, and generally helpful. In the recent past, you've been self-employed, living in a caravan sited on land which you own. The author of the pre-sentence report focuses upon your relationships and linked mental health problems. You had a turbulent childhood, suffering physical and mental abuse. You had a close and supportive relationship with your father, however, and his suicide in 2021 affected you profoundly. Dr. Ramplin has explained that you've experienced mental health problems throughout your adult life, and those problems have included depressive episodes of marked severity. Since your father's death, you've attended Mr. Carruthers, you're now aged 32. The pre-sentence report records that you have 2 children with your long-standing partner. One of those children has special needs. You've worked hard throughout your adult life and you are, or were, financially secure, having been employed at Cumbria Turf for many years. The author of the report describes you as demonstrating emerging remorse, although still struggling to accept responsibility for your actions or to recognise the impact of your actions on others. You have no previous convictions. As I've remarked, I must take into account in your favour any mitigating factors. I've considered Mr. Graeme's background mental health problems carefully. However, it appears from the report of Dr. Ramplin that you, Mr. Graeme, do not regard those problems to be relevant to your offending, nor do I. Your offending that night was not in any way caused by or linked to your mental health. Further, according to the report from Dr. Ramplin, your depressive illness is currently in remission. You reported to him suffering no significant depressive symptoms, no suicidal ideation. You demonstrated reasonable function both in interview and in prison, and you are coping well in prison. Whilst acknowledging that your mental health history is informative background, there is nothing in the material available to me today to suggest that a custodial sentence will weigh more heavily on you by reason of your diagnosis or your mental health history. I've also read and understand the testimonial evidence served on your behalf and take into account that your caravan has been damaged and that you've received hate mail as a consequence of your conviction for these offences, but I'm afraid I do not regard these as mitigation either. I've taken into account Mr. Carruthers' personal circumstances. I accept that Mr. Carruthers is an active caregiver to his children, including one with special needs. But I'm told that that child is coping well in mainstream school and that your partner is able to care for the children. In short, whilst acknowledging again that your personal background is informative, it does not, in my judgment, afford a basis for reducing your sentence. I accept that in the case of Mr. Carruthers, there is some modest mitigation in the form of an absence of previous conviction which justifies a discount. Mr. Graeme, you have previous convictions, but as I've said, they are for very different offences to those which you face today. I've considered carefully whether I should afford only Mr. Carruthers a degree of credit to reflect his character. However, this is a case in which I have an overwhelming sense that both defendants should receive the same final sentence. Mr. Carruthers, you will receive the benefit of the discount for having no previous convictions. Mr. Graeme, you will receive the same discount, although you do in fact have convictions, but they are not, for my purposes today, relevant convictions. I'm required to pass a sentence which falls within the offence range set out in the guideline, unless I'm satisfied that it would be contrary to the interests of justice to do so. Considering count 1 on its own, I'm satisfied that the guideline offence range is sufficient, taking into account aggravating and then mitigating factors. And the Crown accepts that the offence in count 1 is properly dealt with as being in the most serious category covered by the guidelines without the need to go outside those guidelines. As I've already said, the guideline range for a category 1A offence extends to 4 years imprisonment. Count 2. As I've remarked, the starting point in the guidelines for count 2 is a high-level community order. Again, I must consider whether there are factors in your cases which justify an adjustment of that starting point upwards or downwards before consideration of aggravating and mitigating factors. There are no such factors, but the offence in count 2 is, in my judgment, significantly aggravated by the fact that you caused damage to a heritage asset, Hadrian's Wall. The actual damage to the wall was relatively modest, comprising only of spoiling and fracturing of some of the stones, but it is a World Heritage Site and a protected monument. As Mr. McFarlane of Historic England has stated, the wall is a major archaeological site and an important tourist draw to the region, and I'm satisfied that a short custodial sentence is appropriate for count 2. I've had regard to the Sentencing Council guideline on totality. Counts 1 and 2 arise from the same facts. In these circumstances, it is appropriate that I impose a sentence in count 1 which reflects your overall criminality and impose on count 2 a sentence which will be served concurrently. When considering the sentence to be imposed on count 1 in these circumstances, it is not a simple arithmetical exercise of adding one sentence to the other. The sentence which I pass must be just and proportionate. The sentence on count 1 will therefore incorporate a part of the sentence on count 2, but not the whole of it. I made a reduction to the sentence to be imposed on count 1 to reflect, in Mr. Carruthers' case, the absence of convictions, and in Mr. Graeme's case, the absence of relevant convictions. The increase which I make to the sentence in count 1 to reflect part of the sentence in count 2 has the effect of cancelling out that reduction. Finally, I am satisfied that the term of imprisonment which I pass is the shortest term commensurate with the seriousness of your offending. I make deprivation orders in respect of Mr. Graeme's Range Rover and Mr. Graeme's mobile phone, both of which were used for the purpose of committing or facilitating the commission of offences. The victim's surcharge applies. Stand up, please. Mr. Daniel Graeme, Mr. Adam Carruthers, I pass the same sentence in respect of you. The sentence is, on count 1, 4 years and 3 months imprisonment. On count 2, 6 months imprisonment, but to be served concurrently with the sentence on count 1. Daniel Graeme, you've been in prison since the 21st of December 2024. Adam Carruthers, you've been in prison since the 9th of May of 2025. The days that you've served will count towards your sentence. I've imposed a sentence of 4 years and 3 months imprisonment. You will be released no later than 40% of the way through the sentence, and the remainder of the sentence will be served on licence in the community. You must comply with all the conditions of your licence, failing which you will be at risk of recall to prison to serve the remainder of the term in custody. Thank you. I may go down.